Ready to strengthen your reading comprehension? Take a listen.
It's wild how a simple fender bender in a parking lot can just explode into this huge, complicated legal mess. But today, we're not just looking at a traffic case. We're going to break down an absolute masterclass in legal strategy and see how the right argument can completely take apart the state's case from the inside. All right, so here's our roadmap for today. We're going to start with what actually happened at the flea market. Then, and this is important, we'll look at the flawed arguments that nearly sank the whole thing. From there, we'll get to the strategic pivot that turned it all around. We'll dismantle the state's case, piece by piece, talk about getting the vehicle back, and then wrap it all up with the single biggest takeaway from this entire situation. Okay, first up, the flea market incident. Let's set the stage and see how this all got started. So it all begins with something super mundane, a minor collision in a flea market parking lot. Our subject, who we're going to call friends-in-law, gets into this fender bender. But what happens next is what matters. Things escalate fast. 2 criminal charges get filed and the car gets towed. Just like that, a small problem became a very, very big one. All right, section 2, the 2 flawed arguments. Now you really got to pay attention here, because we're looking at the first arguments made in this case, a path that feels powerful, but almost always leads straight to a dead end in a real courtroom. And this slide just lays it out perfectly. On the left, you've got these big philosophical arguments, stuff like the private man theory. You see how that side looks like it's crumbling? That's because, legally speaking, it is. Courts just see this stuff as frivolous. These arguments don't just fail, they actively hurt your case by destroying your credibility with the one person you absolutely need to convince, the judge. This quote from the legal analysis just hits the nail on the head. These arguments aren't assets to your case, they are credibility liabilities. It's like you're taking out a loan against your own reputation in court. You're basically telling the judge you're not here to play by the rules, and that's a debt that is incredibly hard to pay back. So if those arguments were the problem, what was the solution? Well, the defense needed a total 180. It was a real aha moment. It was time to stop arguing about philosophy and start arguing the only thing that actually matters inside a courtroom, the law itself. And this is the absolute key to the whole thing. You stop trying to argue that the castle doesn't exist. Instead, you pull out a magnifying glass and you inspect every single brick, every crack, every bit of mortar. The new mission is to force the state to prove, with surgical precision, that they've met every single legal requirement. You're not attacking the law itself, you're attacking their use of the law. So how do you do that? Well, you use these really powerful legal tools called canons of construction. The best way to think about them is like this. If a law is a complicated machine, the canons are the official instruction manual from the manufacturer. They are the rules judges have to use to figure out how the law is supposed to work. The strategy becomes using the state's own instruction manual against them. Okay, now for the masterclass. Let's see how this strategy goes from just a theory to a precise, element-by-element attack on every single charge. So first up, the insurance charge. No big, broad challenge here. Instead, the attack is laser-focused on 3 potential weak spots. First, the law is specific. It applies to vehicles registered in this state. Was this one? The state has to prove it. Second, the state has to prove there was no financial responsibility. Just not having a card on you isn't enough. And third, the location. The law says street or highway, but this happened in a private parking lot. That single detail could be enough to get the charge thrown out. All right, next, the resisting an officer charge. It's the exact same playbook. First, was the officer even performing a lawful duty? Because if the order wasn't lawful to begin with, you can't be guilty of resisting it. Second, the law in North Carolina requires an actual act of resistance. Just arguing or hesitating for a second doesn't count. And finally, willfulness. The state has to prove it was a deliberate choice to obstruct, not just a moment of confusion. Okay, now this is where the strategy gets really, really smart. The analysis realized that the biggest point of leverage wasn't even the criminal charges, it was the tow. So they hit him with a 3-punch combo that creates a ton of pressure. First, you challenge the whole legal basis for towing the car. Was there an arrest? No. Was the car a traffic hazard? No. Was there a warrant? No. So, was the tow even legal? Second, you demand a hearing and force the state to get on the stand and prove they had probable cause. And third, you file a whole separate civil lawsuit for conversion, which is just a legal term for unlawfully taking someone's property. That creates a brand new world of problems for the state. So, after all that, what is the big lesson here? What's the one core idea we can walk away with from this whole thing? It all comes down to this. The losing argument, on the left, that's like shouting at a brick wall with a megaphone. You might feel powerful, but you're not going to make it dent. The winning argument, on the right, that's like using a tiny pair of tweezers to pull apart the links in a chain. It's quiet, it's careful, it's precise, and it completely dismantles the opposition's case. And that's the principle. That's the whole ball game right there. Precision beats passion every single time. Look at the scales. Passion is fiery, sure, but it's light. It doesn't carry much weight in a courtroom. A precise, technical, legal argument, that carries real weight. That's the kind of argument a judge has to take seriously. And that kind of leaves us with this final thought, doesn't it? This whole case proves that the facts are only half the story. The other half, the half that might matter even more, is the argument you choose to build with those facts. It really makes you wonder, how many legal battles out there are lost, not because the facts were bad, but simply because the argument was wrong.
For my head, I still live for the prize. Whoa, whoa, whoa.